here at the American Family Association and was the lead attorney on a very, very important pro-life piece of court action. And the ruling came down today from the Supreme Court. So the Supreme Court issued a ruling today on a case that Michael DePrimo, my next guest, has been working on. In fact, he started working on this case when he was still with the American Family Association, sort of started the initial proceedings kind of on loan from Don Wildman here at the AFA. Michael, welcome to Focal Point with Brian Fisher.
Thank you, Brian. Good to be here.
Yeah, good to chat with you again. It's been several years since you and I have chatted. But, Michael, for people that may not be aware of the case, give us a little bit of history, a little bit of background, and then tell us what happened today and why it's important.
Sure. The name of the case is McCullen v. Coakley. In 2008, Massachusetts adopted a statute that created a 35-foot fixed buffer zone around all abortion clinics. We filed suit in the federal court. We lost at the district court. We lost at the Court of Appeals. And today the United States Supreme Court struck down that law, essentially saying that buffer zones around abortion clinics are unconstitutional.
And another good part about the ruling, Michael, is the vote count.
9-0, no dissent. Even the liberals agreed.
Wow, this is absolutely a unanimous decision that these buffer zones around abortion clinics are unconstitutional. And just to be clear here, Michael, we're talking about pro-lifers that were not on private property. They were on public property, sidewalks and so forth. Am I right?
That's exactly right. This particular statute only encompassed sidewalks and streets and other public ways. It did not encompass private property.
And so the court said, look, and this was sort of a free speech case, am I right? Is that kind of the heart of the issue here?
That's exactly right. The court struck it down on First Amendment grounds.
Because they were saying, look, there are people inside that 35-foot bubble, the people that support abortion, they've got the right to speak, they've got the right to talk. It's only the people that have a different point of view that are silenced and not allowed to speak. But this is on public property. You can't censor or discriminate. That's viewpoint discrimination. Just can't do it. Conflicts with the First Amendment.
Well, essentially, that's only the four dissenting justices, which were the conservatives, actually explicitly said that. Justice Roberts, who wrote the opinion, struck it down because it was not narrowly tailored to the government's legitimate interests. But nevertheless, the buffer zones are gone. They're unconstitutional.
Now, what is that going to mean? It's a 35-foot buffer zone. You've got other states or communities that I believe also have buffer zones, maybe with a narrower zone of whatever. How is this going to affect buffer zones that may be smaller in scope, maybe 6 feet or 8 feet, something like that? What do you think will happen with those?
Well, the heart of the opinion by the Chief Justice is that government may not create buffer zones around abortion clinics unless it's unable to use other types of laws to protect its interests. For example, there are laws that prohibit obstructing, blocking, trespassing, harassing, hindering, detaining. And those laws fully protect the government's interests without a buffer zone. And the Supreme Court said they have to use those type of laws rather than buffer zones.
Now, part of the issue here, too, Michael, correct me if I'm wrong on this, but part of the issue here, it seems to me, is that the folks that were gathered outside this abortion clinic in Massachusetts were not there to protest. They weren't waving signs. They weren't yelling. They were trying to talk to these women, give sidewalk counseling to these women who were going into the abortion clinic. So it really was a classic case of them having the opportunity to engage in constitutionally protected speech in order to offer counsel to somebody who was about ready to make an irreversible decision.
That's exactly right. And the Chief Justice, in his opinion, actually pointed out that distinction. My clients were not interested in protesting. They were interested in peacefully, privately offering alternatives to abortion to men and women who were going into Planned Parenthood.
Now, one last question, Michael, before I let you go, and I appreciate you taking time to talk to us. It's a great day for you, so I congratulate you on arguing this case so well. It's a better than that. It's a great day for unborn babies and for those in the pro-life movement that want to be able to offer council. But let me ask for your opinion. How important is this decision?
This is a watershed decision because the Supreme Court has been chipping away at the rights of pro-lifers for several years now, for several decades. And this basically turns the clock back to the point where pro-lifers are going to have the same rights as anybody else to engage in speech on public sidewalks and streets.
Our guest has been Michael DePrimo, the lead attorney on a huge pro-life case today, ruling issued just today by the Supreme Court, 9-0, unanimous, that buffer zones around abortion clinics that prevent pro-life sidewalk counselors from offering alternatives to abortion-minded women, that is flatly unconstitutional. Well, Michael, again, God's best to you, my friend. Congratulations on a job well done.
Thank you. God bless you.
Michael DePrimo, victorious attorney in the Supreme Court ruling today, rejecting the buffer zone around abortion clinics. And as Michael suggested, this was a huge issue. So congratulations to Michael. Good day for him. Good day for the pro-life movement. A good day for unborn babies. Okay, we will continue with the program after the break. You are listening to Focal Point on AFR Talk. Got time maybe to squeeze in one clip. Let's grab clip number 1 if we can, Rob. This is Steve Kornacki, MSNBC, talking to Jonathan Turley. And speaking of laws and all that, Jonathan Turley talking about President Obama and his willingness to defy the Constitution and defy the law. Let's listen.
The House. So, Jonathan, let me bring you in now. We covered the explicitly political. Let's get to the legal then. Okay, the Speaker of the House is intent on suing the President of the United States. It's unclear, apparently, from the remarks John Boehner made today, from the information that they've put out, exactly what the specific, examples they're using here of presidential overreach, of executive orders that they think sort of undercut Congress. But and you've been following this, sort of their complaints for the last few years. Really, legally speaking, is there any kind of a case here?
Well, I think there is a case against the president for exceeding his authority. I happen to agree with the president on many of his priorities and policies, but as I testified in Congress, I think that he has crossed the constitutional line.
So where has he crossed it? Like, what specific issues he crossed it on?
Well, when the president went to Congress and said that he was going to go it alone, it obviously raises a concern because there's no license for going it alone in our system. And what he's done is very problematic. He shifted $454 million in the ACA from an appropriated purpose to another purpose. He's told agencies not to enforce some laws like immigration laws. He has effectively rewritten laws through the act of interpretation that I find very problematic. While I happen to agree with him, I voted for him. I think this is a problem.
Now, Jonathan Turley, hardcore leftist. He's a professor of law, I think, at George Washington School of Law, frequently consulted by cable outlets to be the constitutional expert. And John Boehner going to take President Obama to court over exceeding his power. And Jonathan Turley says they got a great case here. Basically, Jonathan Turley saying they've got a case for impeachment if they want to pursue it. Back in 2.